Okay, well, hi everyone, and a massive sporting welcome to this season's newly revamped edition of our Sports Law Academy series. I'm Simon Leaf, and I lead the sports group here at Mishcon. I'm coming to you live from Africa House in London, despite what the backdrop behind me might suggest, and it's an absolute pleasure to have you on the Zoom today. I speak on behalf of our team when I say the launch of each year's Sports Law Academy is one of our favourite parts of the year. And it's always great for us to meet and get to know a new set of sports law enthusiasts and the next generation of sports lawyers, usually in the Mishcon bar following each session. It goes without saying though, and as we are all now used to hearing, this year is going to be different, but ideally different in a positive way. The move to online only sessions means that we've been able to accept more applicants onto the Sports Law Academy from more places around the world, and have a group with a more richly varied and diverse background than ever before. We've got a mix of professional athletes, coaches, qualified lawyers, as well as bright and incredibly passionate students. And as a result, there's going to be even more opportunities for interaction between participants and speakers, and for you to make new connections this year. With that in mind, I encourage you to make great use of this network that you're now a part of. And before I hand you over to Tom Murray, otherwise known as Sports Law Tom, an associate in our sports group here, he's going to say a few more words about what we have in store for you over the next 8 sessions, and then lead today's session on understanding the sports law landscape and sports disputes. I wanted to give you all a brief introduction to our team here at Mishcon. In essence, we're a team of 25 lawyers from around the firm that specialise in the full range of sports law related matters. We act on everything from the buying, selling and financial investment into football, rugby and esports organisations and tournaments, all the way through to highly complex immigration and employment law related matters. We advise on some of the most high profile commercial, technology and IP related sports matters, which includes international broadcasting and sponsorship work, as well as stadium and team naming rights matters. The team also regularly provides regulatory advice to both the rule makers and the rule takers, particularly when it comes to financial fair play, third-party ownership, intermediaries, and multi-club ownership regulations. Last but not least, and the subject of today's talk, we've advised on some of the highest profile sports disputes in recent years across a number of different sports on behalf of governing bodies, owners, sponsors, athletes, intermediaries, sports technology companies, and even insolvency practitioners. Despite being located in London, the majority of our work involves international clients, assets, and/or individuals. Finally, from me, please don't hesitate to reach out to us with your comments, questions, and feedback, not only during each session by using the Q&A functionality for questions to the panel, or the chat functionality for any other issues, but also after the session too. We want to hear from you in order to make these sessions as valuable to you as possible. I really hope you enjoy this year's Sports Law Academy. I'm now absolutely delighted to hand you over to Tom Murray. Tom.
Thanks very much, Simon. Hello, everyone, and welcome to Module 1 of the Sports Law Academy. So we're really delighted you can all join us here today for the start of the 2020-2021 academic year. And as you can see behind me, as long as I don't move my head too quickly, it's a beautiful day at Wembley, the home of English football, and the weather in England has defied the odds. I'm incredibly excited to be presenting to you today. As Simon said, my name's Tom Murray. I'm the course convener of the Sports Law Academy, and I'm an associate in the sports group. We're joined today by representatives from around the world. So I think this year we've had just over 1,000 sign-ups for the Sports Law Academy, including people from the Premier League, Arsenal, Chelsea, the Belarusian Football Federation, the Brazilian Olympic Committee, and even the Jamaican Bobsleigh Federation. Whether you're an athlete, a lawyer, a non-legal professional, or simply someone that's just trying to improve their understanding of contemporary sports law issues, then this is the course for you. Now, as you'd have seen from our prospectus, which is of course available on our website, if you just Google the Mishcon Sports Law Academy, you can find us on there. We've designed 8 modules that really showcase the breadth of the sports work that we do here at Mishcon, from esports and immigration to FFP and gender equality. Now, I'm not going to go into sort of full details of the modules because you can check these out in the prospectus for more information. We're going to be releasing each module towards the end of each month, and the next module after this comes out on the 30th of November. You should receive an invitation for each module about 2 weeks before it comes live. and you do need to register for each module in order to attend. Some of the modules will be pre-recorded, and that includes our next module, and the pre-recorded sessions will be made available to you as the course progresses. Now, all of our modules are recorded, and subject to any technical failures, which can always happen, recordings will be made available on our website shortly after each lecture for you to enjoy at your own leisure, sorry. There's no obligation to attend all the modules, and if some are more appealing to you than others, then feel free to attend the ones which you think are most interesting. Today, we're also delighted to welcome speakers from around the firm. We also have a number of leading barristers, lawyers, and advisors who we normally work with, who are able to share their knowledge and expertise as part of the Sports Law Academy. Now, as with every conference, I do need to run for a few housekeeping rules. So this is designed, as Simon says, to be an interactive session. So if you have questions, we've got a Q&A feature at the bottom in Zoom. Just click on the Q&A, pop your questions in there, and I'm going to try and run through as many of these as possible at the end of the session. Drinks and light refreshments are available in your fridge, so please do help yourself. If you hear an alarm go off, please note this is not a drill. It's most likely your delivery order. We've tried, now that's the end of the bad jokes, I promise. We've tried to make this year's session as inclusive as possible. So if you don't understand something, please don't hesitate to reach out to us or any of the speakers. And that goes throughout the Sports Law Academy. Now, for certain modules, we'll be sharing further reading to allow you to delve deeper into topics. And this would include stuff like cases, articles, or other publications, which we think may be relevant. Now, today's module is all about understanding the sports law landscape and trying to give you a basic understanding of sports disputes. Now, this could be a course in itself, so we've tried to streamline things as much as possible. Now, I'm just going to present my, my slides, if you bear with me 1 second. This is when I said about the technical difficulties. One sec. Okay, so hopefully you can all see my slides. If not, please do let us know in the chat function. So let's get started. You can't really run a sports law academy without giving an understanding of what sports law is. So here we're going to be asking, does sports law even exist, or is it just sport and the law? And when we're asking this question, we're also thinking about, does the law apply differently to sports than it does to other sectors? Now, the historical view that's held by many, or at least it was historically, was that sports law and a sports lawyer is just a false invention. It's something that me and Simon call ourselves in order to make our job sound a little bit more sexy. And the reason people said this is because there was historically no jurisprudential basis or juridical foundation for sports law. People would say that it's simply an amalgamation, a grouping of different areas of law, such as contract, intellectual property, tort, and tax. However, the more modern view is that sports law should be recognised as a body of law in its own right. And there's sort of three main reasons why people say this. The first is that we've seen the development and the emergence of sports-specific courts and tribunals. And this is something that Mark's going to go into detail in later on in the talk. For example, the Court of Arbitration for Sport and sports resolutions. Now, we've also seen the development of distinct legal doctrines that are specific to sports law. And an example of this is the idea of comfortable satisfaction in the burden of proof. Now, if you watch any criminal TV show where there's barristers arguing in court, you'll be familiar with the idea of the burden of proof. In the criminal law, the burden of proof is beyond reasonable doubt. And in statistical terms, this is often seen as a sort of a 95% sure. Are you 95% sure that the person standing in the dock is guilty? If so, then he should be punished. If not, he should be acquitted. You might also be aware of the civil burden of proof, which is a balance of probabilities. And this is often seen in statistical terms as a sort of 50-50. So if the judge believes that one side has 51% of the arguments and they're more persuasive, then that party should win and the 49% should lose. However, in sports law, and specifically in the context of anti-doping cases, we've seen this emergence of comfortable satisfaction. And this is a standard that's well known to the Court of Arbitration for Sport. And it's the normal standard to be applied in CAS cases. Now, sometimes this is described as a variable standard, but CAS likes to think of it as it takes account of the individual circumstances of a particular case. And the underlying basis of this is that the more serious an allegation, then the more cogent the supporting evidence for the allegation must be before it can be proven. And it's often seen as higher than a balance of probabilities, which you'll remember is the civil standard, but also lower than the criminal standard of beyond reasonable doubt. Okay, so if we're going to accept that sports law exists, then what about esports law? Well, the common view for this is that esports is still very much in its infancy, and it's therefore premature to consider this as an area of law in itself. But I'd like to ask the question, are times changing? Well, in some ways they are. Firstly, we've seen the emergence of esports specific tribunals, such as the WESA or the World Esports Association, who've created an arbitration court for esports. Now, I won't lie to you and say that this is something that is typically used by esports parties, but it is something that's been created. We've also seen the emergence of bodies such as the Esports Integrity Commission, which is headed up by a guy named Ian Smith. Now, this is set up to be the recognised guardian of integrity in esports and to take responsibility for disruption, prevention, investigation and prosecution of all forms of cheating. That sounds very fancy, but what do? They typically investigate and work alongside betting operators to understand match fixing in esports. And if they identify suspicious betting patterns, they then try and take action against players who are trying to cheat or throw matches in order to win money. Finally, we've also seen a creation of law firms that are dedicated to video games and esports. So I've just been advising on a transaction involving an esports player called Alex McMeekin, who moved from a French team, Team Vitality, based in Paris, to a US team called Cloud9. And the deal was worth $1.65 million and is one of the biggest transfers ever in Counter-Strike. And the counterparty who we were acting against was called ESG Law. And they describe themselves on their website as the first law firm in the world that's exclusively dedicated to esports. Well, if a law firm is going to describe themselves as the first firm dedicated to esports, then perhaps esports law should be recognized. My personal view is that we can draw a distinction here between sports law and esports law. And the distinction is that legal doctrines and concepts have been established and developed over a number of years in sports law when they haven't yet had the chance to do so in esports. So I would say it's still premature to recognize esports law as an area of law in its own right, but I would say that times are definitely changing. So does sports law exist? Well, the follow-up question of that is does it really matter? I can't say that Simon, me, Mark or Pete sort of sit there every day thinking, oh, I wonder whether sports law does exist. On a practical basis, it doesn't really matter. It's a really interesting academic debate, but yeah, does it make a day-to-day difference? I would say not. And perhaps it's time to sort of reframe this debate and consider sports law as a lens through which we can understand, analyze or apply different areas of the law. Now, one of the questions that I'm often asked is do sports lawyers approach matters differently to other lawyers? And just to give an example, Simon and I typically advise on commercial contracts. Some of these might be in the fashion realm, some of them might be cosmetics, some of them might be technology, and others will be in sports. And I think to an extent, there's a degree of pragmatism, efficiency, and an ability to deal with complexity that arises in sports law that perhaps doesn't arise in other areas. And just to give you an example of this, so Simon and I once worked on a settlement agreement for an African footballer who was playing in China. And typically a settlement agreement can run 10, 15, 20 pages. However, we knew that this matter had to be dealt with succinctly, and we knew the document was going to be translated into Chinese. So we therefore had to draft a settlement agreement that was only 2 pages long. We didn't just put it into really small font. We took out the key elements of the agreement and reduced it down. And that sort of, the reason we did this is because it needed to be sent to a Chinese football club who needed to understand the document and to try and minimize the opportunity for the other side to dispute it. Now that's something that could arise in other areas of law, but it was a particular requirement for the client in this case that we needed to address. Okay, so now we've asked one of the most fundamental questions, and probably the most fundamental question that we're going to ask on the whole of this course. And now we can sort of move away from the academic discussion of sports law and into some pragmatics. So now we're going to talk about this concept of the specificity of sport. And this is a concept which basically discusses how the law applies differently in the context of sport. And this is one of the reasons why people want to recognize sports law as an area of law in its own right. So the European Commission describe it as it refers to the inherent characteristics of sport, which sets it apart from other economic and social activities. It's also a recognized legal concept by the European Court of Justice, which is a European court which hears matters of EU law, particularly in the context of competition law. Now, what this doesn't mean is that sport doesn't have to comply with other areas of law, but what it means is that sporting rules, regulations, and practice are often given special treatment, and sometimes are given a bit more leeway and often treated as an exception. And it means that the law can sometimes apply differently in sporting context than it can in many other contexts. So I've got 3 examples here to talk you through. The first is competition law. Now, competition law is the idea that we should promote competition in the market in order to benefit consumers. And there's lots of rules which try and encourage market competition, and they do stuff like preventing price fixing and trying to generally prevent state bodies from supporting private individuals. And this often comes up in the context of club ownership. And one thing that we've been sort of thinking about recently is Manchester City. Now, the City Football Group, who own Manchester City, own 10 different football clubs. So they own Man City, New York City, Melbourne City, Yokohama in Japan, Torquay in, I think it's in South America, Mumbai City as well. And you would have noticed that none of these teams compete in the same competition. They're often based in different jurisdictions, and the risk of them ever competing in the same competition is minimal. The only 2 that could ever do so is Man City and Girona. And you might be asking why City structure things in this way. Well, there are rules in place which prohibit any individual or company from owning more than one club if those clubs compete in the same competition. And those types of rules that exist typically will be regarded as anti-competitive in that they prevent or reduce competition in the market. However, in sports, this is often recognized as a proportionate means of achieving a legitimate aim in order to protect the integrity of competitions. So these rules, which exist to prohibit clubs from competing in the same competition, being owned by the same owner, have a legitimate reason for existing and are therefore given a degree of an exception to apply. Now, the second example we've got is of transfer windows and their interaction with the concept of free movement of people. Now, free movement of people is the idea, is an EU concept that people should be able to work in different places and should be able to move freely between EU member states. And transfer windows were introduced as part of a compromise agreement with the European Commission. And the reason they exist is because they try and preserve the contractual stability for both a player and a club, whilst also allowing movement during certain prescribed periods of the year. So you'll all be aware of the summer transfer window and the winter transfer window. So here we see an interaction between EU law and an exception being introduced to allow certain restrictions to exist on the concept of free movement of people because of the special nature of sport and because of the legitimate reason of trying to encourage contractual stability. Now, the final example we've got, which also arises in the EU context, is this idea of state aid. Now, state aid is when governments give financial assistance to companies or organizations, and this is often seen as having the potential to distort market competition. So just as an example, if the Conservatives tomorrow decided to build a stadium on behalf of Chelsea, that might be great for UK sport, but it could also be seen as distorting market competition because it pushes Chelsea's ability to raise revenue above that of its competitors. Now, state aid can often be seen in the form of direct cash. It can be grants, it could be indirect aid, such as tax breaks or credits. And under EU rules, there are restrictions applied to state aid without the approval of the EU Commission. Now, the EU now recognise that in relation to stadiums, aid is generally acceptable where facilities have some sort of multifunctional character and are not used exclusively by any single professional sport user. Okay, so now we've understood what sports law is, we've also interrogated what the concept of the specificity of sport is, but who are the main players in sports regulations? Now, in order to understand and navigate the different regulatory regimes, we first have to have an understanding of how these regimes operate. And this is one of the biggest challenges that sports lawyers have, trying to understand and navigate the different sources of law, the different rules, the different bodies, and how these interact with one another. Now, in sport, the regulation involves a mixture of public and private actors. So the public actors will be known to you. We have the government or parliament, and in particular, we have the Department for Digital Culture, Media and Sport. We have the courts of England and Wales. We have the European Union, unfortunately, just for now. And we also have the Council of Europe, who are responsible for the European Convention of Human Rights. But we also have private actors, and many of the private actors are joining us today as participants. We have global regulators such as FIFA or the IOC. We have continental representative bodies which group together national associations such as UEFA. We have the European Boxing Union and people like the Association of National Olympic Committees of Africa. Now, we also have national governing bodies such as England Boxing, the RFU, or one of the participants today is the Brazilian Olympic Committee. Now, often these bodies will have their own disciplinary regime and committees that are set up. So I sit as a panel member as part of England Boxing's disciplinary committee. Finally, we have dispute resolution bodies, and this is something that Mark's going to go into in further detail, such as the Court of Arbitration for Sport, the FIFA Dispute Resolution Chamber, and sports resolutions. And trying to understand how these different regulatory regimes overlap and interact with one another is one of the most important things that you'll need to do as a sports lawyer. Now, just to give you one example of this and how there's lots of different overlapping areas of law and regulation, I'm going to talk about the fight between Anthony Joshua and Kubrat Pulev, which is due to take place on the 12th of December 2020 at the O2. So here, Anthony Joshua is going to be defending his IBF, his WBA, his WBO, and his IBO titles. So here we've got 4 different governing bodies who each have their own rules and regulations. As part of the fight, there'll also be 2 main anti-doping bodies. So in the UK, we have UK Anti-Doping, and we also have a body called VADA, which is the Voluntary Anti-Doping Agency. And VADA is a body which Anthony Joshua puts as a contractual obligation that his opponents must sign up to. And this introduces more regular testing in order to detect whether someone has taken any sort of substances which might enhance their performers. To think more deeply about the other areas of law which might come into play, well, the fighters will have bout agreements between the promoter and the fighter. They'll also have management agreements between them and their manager. The broadcasters will have their own contracts with the promoter, so Sky Sports and DAZN, who will be the promoters for this fight. We'll have sponsors such as William Hill, StubHub, and JD Sports, plus each individual boxer will have their own individual endorsement agreements. And these are all different contractual relationships which need to be navigated. So you can see how coming together, this can create a real complex web of contractual and regulatory relationships which interact with one another. From a sort of consumer law perspective, obviously we'll have the ticket terms and conditions. From an intellectual property law perspective, we'll have the different logos which will feature as part of the canvas. They'll also be displayed on the fight poster and in any advertisements. To give another example of how lots of different areas of law can interact, I'm going to talk a little bit about cheating in esports. So in August 2019, we had the first ever Australian police investigation for match fixing in esports. And as part of this, 6 people were arrested for losing matches on purpose in a popular game called Counter-Strike, which is where one side is a group of terrorists and the other side is a group of counter-terrorists. Now, as part of this investigation, there were lots of different areas of rules and regulations which came into play. Firstly, and perhaps the most serious, there was the criminal law. So the players could face up to 10 years in prison for engaging in conduct that corrupts a betting outcome. Now, this is obviously a pretty serious charge, and many people think it's quite surprising that just by losing a game in esports, you could face such a sanction. In terms of the regulatory side of things, well, the conduct by cheating and losing games on purpose, this would amount to the breach of the rules and regulations of and also the rules on betting on esports of the regulators. We'll also see that it's a breach of the tournament rules, including those backed by the game's publisher, which is called Valve. Under contract law, sponsors of the individual players or teams may have the right to terminate their contracts on the basis that the players have engaged in conduct which has brought them into disrepute. And finally, from a sort of employment law perspective, the player's conduct will almost certainly constitute gross misconduct, which will enable the team to terminate the player's contract. So here you can see how many areas of law can come into play with just one particular investigation. Now I'm going to end this part of today's session by focusing on the concept of the autonomy of sport. And what this means is it's the idea that sports bodies should be able to organise themselves, make decisions, and to an extent self-regulate with limited intervention from public bodies. And the reason we have this, the reason why people think the autonomy of sport is important, is one, that sport should be free from government and political interference. And if you have government interference, this can really pose a challenge to the integrity of sport and the integrity of competitions. So just to give two examples, which we've been involved in. The first is the Qatari diplomatic crisis, which some of you will remember from a couple of years back, where many of the Arab states turned against Qatar. And this was a real crisis in the context of sport. There was a company called beIN Media, who were a Qatari-owned company, who found itself subject to various forms of discrimination on the basis that it was a Qatari company. So people were refusing to do interviews, sometimes the journalists were subject to abuse. And this was part of an ongoing diplomatic crisis where Egypt, Saudi Arabia, and many others turned against Qatar. And here we saw how sport had to grapple with the competing interests of trying to encourage different countries to cooperate with one another, and also trying to prevent different states from intervening into sport. The second example I've put on there is a case which I was involved in of Khalkhaba Malboum and ANOCA, which stands for the Association of National Olympic Committees of Africa. And this was the first ever case brought before the Court of Arbitration for Sport for infringing the autonomy of sport. And here, our client, Khalkhaba Malboum, was accused of accepting improper funding from his government in order to run for the presidency of ANOCA. Now, I'm pleased to say we managed to have him cleared of all charges, and he was cleared of all wrongdoing. But here we saw how simply receiving funding from a government could be seen as potentially infringing the concept of the autonomy of sport. Now, finally, I'm going to be asking the question, why do sports and why should sport regulate itself? Well, one of the arguments in favour of this is that it requires particular expertise and an understanding in order to adjudicate sports disputes. Now, this argument is often used in the context of employment law, in that you should have employment specialists who sit as panelists or as judges on employment matters, because they have a particular understanding of the employment relationship. And similarly, in a sports dispute, let's say you have a dispute between a player and an agent, you may want to have someone who has particular expertise, who understands the relationship between players and agents and the way football works in order to adjudicate on a particular dispute. Now, I'm now going to pass on to Mark Afiva and Pete Nunn. So Pete Nunn is a sports specialist and is also head of sports disputes at Mishcon de Reya. I'm just going to stop sharing my screen. Bear with me 1 second. Okay, should have stopped. Pete, over to you.
Thank you, Tom. Sports disputes can arise in all sorts of contexts. Picking up on what you're talking about, Tom, about the distinction between is there sports law and is there just normal law that people call sports law, you get the disputes that are fought in the regular courts, which are not really any different in legal terms and procedure to the types of dispute that you find in any other industry. For example, you might get a sponsor seeking to terminate a sponsorship agreement because it feels the team it is sponsoring is underperforming. I've come across that regularly in Formula One, where a team title sponsor seeks to end its sponsorship agreement of the F1 team because that team is not doing as well as it had hoped and it doesn't want to be associated with it anymore. Any disputes over whether that termination of the sponsorship agreement was justified and whether one party owes the other money are likely to be litigated in the courts. And you also get a multitude of court cases, among other things, over things like the ownership and sale of sports organisations. Famous cases that people might have heard of over the last few years involved, for example, Nottingham Forest and Blackpool, particularly vicious dispute involving the Oyston owners. And we're currently, Mishcon, defending a very large case being brought by the unsuccessful bidder for what was the Force India, now Racing Point F1 team. That's the court cases, but there's also this whole separate world of arbitration forms which are entirely specific to sport, of which CAS, Court of Arbitration of Sport, is the most famous. These arbitration forms, which Mark's going to come on to in detail, include bodies at FIFA and UEFA levels, the FA's Rule K arbitration procedure, and specific Premier League and EFL forums. And that's just for football. There's private arbitration forums which are entirely independent of any governing body or any sport. One example that's particularly popular in the UK is called Sports Resolutions. That's used for a lot of athletics doping cases and by the Rugby Football Union. And of course, there's CAS, which you mentioned. So to talk us through the sport and disputes landscape, I'm very pleased to welcome Specialist Sports Barrister Mark Afiva of Matrix Chambers. Mark acts for the PFA, the Professional Football Association. He represents its members before all sorts of tribunals. He's a registered FA intermediary, acting for a number of footballers and agents on their transfer negotiations. And he's also the founder of a sports management consultancy that works to secure solidarity payments that are owed under FIFA rules to small clubs following an international transfer of a footballer. So Mark, over to you, and please do give us an introduction to the sports disputes world.
Thank you very much, Peter. Good morning, good afternoon, good evening, wherever you are in the world. I gather from Tom we've got a very international audience, so that's great to see. And I wish the Sports Law Academy every success. I've not been involved with it previously, but from what I understand, it's been a great endeavour so far. And I think the fact we've been forced to go virtual should actually mean it goes from strength to strength. I will just try and share my screen. Right, just checking. Can you all see my talk?
Yes.
Okay, great. So let me shoot the size right. Okay, fine. So, as an introduction, there are various types of sports law disputes which are dealt with by a variety of forums. You have disputes between governing bodies and clubs, players and governing bodies, clubs and players, players and agents. There's a whole plethora of different ways in which bodies and people fall out. The subject matter of those disputes can vary widely. It could, for example, be matters relating to discipline. So Derby County FC was charged in January this year for recording losses in excess of the permitted amounts of the losses it could accumulate over a 3-year period up to June 2018. The thrust of the English Football League's charges was that the club had sold its ground to its owner, Mel Morris, for £80 million and then leased the stadium back, even though the club shortly prior to that had valued the same stadium at £41 million. This sale allowed the club to stay within the maximum debt of 39 million permitted for the 3-year period. And when it became necessary to deal with it by way of an independent disciplinary commission, the commission dismissed the charges, which was a great outcome for Derby City, not least because Sheffield Wednesday had undertaken a similar creative way of accounting, and Sheffield Wednesday had had 12 points deducted as a result of its activity in July this year. So Derby County got off very, very lightly, one could argue. Other forms of subject matter that are adjudicated upon relate to pay. So for example, players who are having to pursue bonus payments, doping issues, for example. Many of you will be familiar of the case relating to Adrian Mutu, the former Chelsea striker. He was sacked by Chelsea in 2004 after testing positive for cocaine abuse and was ordered to pay £15.2 million in compensation to Chelsea and banned for 7 months. He appealed this decision, not surprisingly, in a range of places over the next 14 years. So the last one that I'm aware of was in 2018 before the European Court of Human Rights. But prior to that, he'd been to the Premier League, FIFA, CAS, and the Swiss Supreme Court. In terms of the disputes and how they are resolved, there are 3 main ways of doing that. You've got the ordinary competent courts and tribunals. You have private arbitrations and mediations, and you also have appeals to governing bodies, whether they're international or national. There is a case from 1954 called Baker and Jones, which says that governing bodies can't exclude the court's jurisdiction. But before anything happens, all internal appeal processes must be exhausted. And that's case law that dates back to 1855, and that's the case of Scott and Avery. So turning now to litigation. This can be commenced in either tribunals or courts. If we look at employment tribunals to begin with, I've listed out a couple of examples there. There is the Jonas Gutierrez case against Newcastle United, and forgive me for the mispronunciation if I did of his name. He brought a claim successfully against Newcastle United for disability discrimination after successfully arguing that he'd been directly discriminated against because of his cancer diagnosis, and also that the club had failed to make any reasonable adjustments in considering whether he had achieved the required number of starts in order to secure a contract extension. A different kind of case, but also discrimination focus, was brought by Eva Crenario against Chelsea Football Club. She was formerly the club doctor, and she brought a claim of constructive dismissal against Chelsea, which was settled, and also a sex discrimination claim against its former manager, Jose Mourinho, which also settled. I believe the Mishcon guys will confirm that they acted for or took part in that matter. Is that right?
That is right, yeah.
Yeah, I thought so, yeah. We also then have the option of matters being dealt with by way of High Court proceedings and also EU litigation. So virtually everyone has heard of the Jean-Marc Bosman case, but prior to that, there is a little known but very important English High Court proceeding called Eastland versus Newcastle United Football Club, which took place in 1964. And it's important to look at this case because it changed the goalpost significantly and allowed or set things up to allow the Bosman case to actually move things on to the current position. So in Eastman, Mr. Eastman was a player for Newcastle United. The club refused to transfer him to Arsenal. At that time, British clubs operated what was called a retain and transfer system, which meant that even if a player couldn't agree a contract with his club, it could still demand a transfer fee. His lawyers argued that footballers should have the same rights as any other employee, and the High Court agreed to an extent and found the system to be an unreasonable restraint of trade. This allowed players to be able to leave a club for free once their contract had expired, unless they'd been offered a new deal, in which case a fee would have to be paid. We then move on to the Bosman case. Jean-Marc Bosman was a journeyman player who was contracted with the Belgian club RFC Liège. When his contract expired, Liège demanded a transfer fee, but no other club was willing to pay it. He was left in limbo. The European Court of Justice found that the transfer system, as it then was, unfairly restricted the free movement of workers. As a result, players were then able to leave at the end of their contracts for free, even if been offered a new contract by their former club. This has had a huge impact on, in particular, the salaries of football players, because clubs who are signing players now, in some situations, don't need to have regard to a large transfer fee. So in order to attract the best players, what they do is they pay very, very high salaries, which attracts the highest caliber players. So having looked at litigation, we now move on to alternative dispute resolution. The first form of that is mediation. And that's a form of ADR in which a third party who isn't involved in the dispute will assist the parties to reach a mutually agreed settlement without the need to go to court or to arbitrate. It's normally very informal. And one of the reasons why it's quite popular is that it encourages negotiations, and importantly, it maintains the relationships between the parties so that once matters are resolved, they can still proceed harmoniously. In terms of sports disputes, mediation is particularly desirable because it allows for greater flexibility in that there are more user-friendly resolution options. It's relatively cheap, it's relatively time efficient, and confidentiality provisions can also apply to any agreement that's reached. In addition to mediation, we also have arbitrations. An arbitration is a procedure in which a dispute is submitted with the agreement of both parties to be adjudicated upon by one or more independent arbitrators who then make a decision as to the merits of the dispute. The advantages of arbitration are that courts can be very expensive. It's much cheaper for athletes in sports such as swimming, where funds aren't particularly plentiful to be able to undertake an arbitration. The courts can also be inflexible. In contrast to arbitration, arbitration rules are typically quite sport specific, and that's also reflected in the sanctions and penalties that are available. For example, points deductions, which of course isn't something that a court, the standard court, can do. Arbitrations can also be very swift. Decisions often need to be made quickly in the sports context, as damages in some situations can be an inadequate remedy. I was recently involved in a matter where I was asked to represent a British show jumper who had been denied selection for the GB show jumping team in the European Championships. The relevant rules required her to submit her appeal within 48 hours of receiving the written reasons for non-selection. The dismissal reasons were provided to her at 10 p.m. on a Friday evening, which meant the appeal had to be lodged by 10 p.m. on the following Sunday. We lodged the appeal at 9:30 p.m. on the Sunday, just in time. The matter was heard within 2 weeks prior to the team's departure for the European Championships. That simply would have been impossible in ordinary civil litigation. Arbitrations are governed by the Arbitration Act 1996 in England, Wales, and Northern Ireland. The Act makes it clear that the emphasis is on speed, reducing costs, and also maintaining fairness in terms of the decision making between the parties. Section 9 of the Act states that courts can stay legal proceedings if they are brought in contravention of an agreement to arbitrate. Similarly, Section 69 does allow appeals to the court on a point of law, unless the parties have agreed to exclude that right but only with the agreement of the other party. The use of arbitrations typically comes about because it's either something which has been agreed in the contractual terms, where they refer to future disputes, or references made in the rules of the relevant sports governing body. They may be incorporated by way of membership of leagues or competitions, may be accepted by conduct, or by the course of dealing. Moving now to the various organs of FIFA. We're going to look at two of them this evening. The first one being the FIFA Dispute Resolution Chamber, otherwise known as the DRC. This was established in September 2001 under FIFA statutes. It consists of 26 members, 13 of whom are club representatives and 13 of whom are player representatives, plus a chair and 2 deputy chairs. Matters before the DRC are normally dealt with by a 3-member panel, including the chair, unless the case is suitable to be dealt with by a DRC judge. And that can be the case if the dispute involves a claim where the value is less than 200,000 Swiss francs. The DRC can adjudicate in relation to a number of disputes, but there has to be an international dimension. Otherwise, FIFA, as the world's governing body, will play no part. So the type of disputes it normally gets involved in include employment-related disputes between a club and a player, for example, where there is an international dimension. Recently, Lionel Messi, arguably the world's best player, in my view he is, better than Ronaldo, he had a dispute with Barcelona, and the dispute at one stage looked like it was heading for the courts or arbitration. That matter could have been dealt with by the DRC, as it was an employment-related dispute between a player and a club with an international dimension. The DRC also deals with matters relating to training, compensation, and solidarity mechanisms. As Peter touched upon in his introduction, it's something that I deal with from time to time in a different capacity. But for those of you who are unaware, in some situations, when a club is involved in the development of a player, and if that player is subsequently transferred internationally for a fee, FIFA's rules require payments to be made by the buying club to all the clubs that were involved in the player's development. It's not always easy for these smaller development clubs to obtain these monies, and therefore, on occasion, there is need to go to FIFA, i.e. the DRC, in order to ensure that those development clubs actually get paid. Article 6 of the rules governing the procedures of the DRC and also the Player Status Committee, which we're going to come on to in a minute, have an exhaustive list of people who are able to use the procedures and are subjects of FIFA's jurisdiction. So those are listed as member associations, clubs, players, coaches, and licensed match agents. The DRC is quite powerful. It is able to impose sporting sanctions if parties fail to comply with its decisions. So those can range from restrictions on playing in official matches for up to 6 months, and it can also include bans on registering new players for up to 3 registration periods. Moving on now to the FIFA Player Status Committee. This ensures compliance with the international transfer regulations relating to players. It has 1 chair, 1 deputy chair, and 22 members. It holds plenary meetings, so those are meetings of everyone who has the ability to adjudicate on its behalf, twice a year, normally in March and October, but subcommittees can determine urgent matters. It is competent to hear different types of disputes. So employment-related disputes between a coach and a club or an association with an international dimension, or disputes between clubs belonging to different associations. It also can deal with disputes where they are related to administrative procedures, i.e. those concerning international transfer certificates, the registration of minor players, and ensuring that eligible players are released to participate with their national teams.
Sorry, Mark, just a heads up on time. We've got about 8 minutes left of this section. So just make you aware.
That's helpful. Thank you. Cheers, Tom. So the PSC can impose sanctions in accordance with the regulations. Again, those can be applied to member associations, clubs, officials, players, and licensed match agents. A recent example of the PSC in action concerned its September 2019 decision in the proceedings brought by FC Nantes against Cardiff City regarding the transfer of Emiliano Sala, who tragically died in a plane crash in January 2019, shortly after being unveiled as a Cardiff City player. Nantes alleged that Cardiff were in breach of the contract for failing to pay the transfer fee, which was 17 million euros, payable in 3 installments as part of the agreement between the two clubs. The PSC ultimately found in favour of Nantes and ordered Cardiff to pay the first instalment of the transfer fee plus interest within 45 days. Moving away from FIFA's tribunals and chambers and coming back to the UK, Premier League tribunals are something which has to be used, or are things which have to be used once you are a member of the Premier League. And all members of the Premier League agree that they will submit all disputes between them to final and binding arbitration. And they also agree that no other system or mode of arbitration will be used to resolve a dispute. Disputes under these rules fall into 3 categories normally, or one of 3 categories. They could be disciplinary disputes or board disputes or other disputes arising from the Premier League's rules. FA Rule K arbitrations are one of the most popular ways of disputes in football being resolved. They're called Rule K arbitrations because within the FA's rulebook, Rule K is a section which sets out the procedural rules for resolving disputes referred to arbitration. The aim is to keep the matters in-house and away from the High Court. Any such dispute that is dealt with by way of Rule K has to be solved finally under those rules. And those matters which are covered by Rule K can include disputes relating to the rules of the FA, the rules of affiliated associations, the status and regulations of FIFA or UEFA, and the laws of the game. Rule K applies to participants, and that's defined very widely. It includes players, clubs and their officials, intermediaries, stroke agents, and all such persons who are from time to time participating in any activity sanctioned either directly or indirectly by the association. In theory, this would include unlicensed agents, but then the question arises, how would you get an unlicensed agent to recognize the FA's jurisdiction? All Rule K arbitrations are, again, governed by the Arbitration Act 1996. Rule K arbitration panels have wide-ranging powers. They can make declarations on any matter before it or before them. They can order the payment of monies. They can prevent actions being taken, or they can require actions to be taken by way of an order for specific performance. Rule K covers a wide range of football disputes. Normally, the proceedings are confidential. They do occasionally leak. One matter that I was involved in, which I can talk about because it was in the press, related to a football agent, Sky Andrew, and the England striker Jermaine Defoe. Sky Andrews sued Jermaine Defoe because Jermaine Defoe had, in breach of contract, decided to use an unlicensed agent, former Spurs player Mitchell Thomas, when Defoe transferred from Spurs to Portsmouth. That matter resulted in Sky Andrews receiving a six-figure settlement from Jermaine Defoe when the tribunal found in Sky Andrews' favour. A very different example of the ambit of Rule K was shown recently by the Football Association when it dealt with the Hull City matter. And it's important to stress that the Rule K arbitrators are actually independent. So there will be times when they'll be asked to adjudicate on matters where the Football Association is either the claimant or the respondent. In this matter, Hull City challenged the FA Council's decision not to allow it to change its name to Hull Tigers. The Rule K panel set aside the FA Council's decision on procedural fairness grounds. So that's an FA panel, Rule K panel, finding against a different organ of the FA. FA rules provide for independent regulatory commissions to hear disciplinary cases. So players who are reprimanded for activities on social media, etc., normally have their matters dealt with by way of independent regulatory commissions. Rule K arbitration panels can consider procedural flaws in an IRC's decision, although the panel cannot look at the decision's merits. So for those of you familiar with English law, it's very much a kind of judicial review approach or ambit that they have. In terms of the jurisdiction of Rule K, some parties have tried to claim that Rule K isn't applicable because they've wanted to go to the High Court because at that time it serves their interests. There have been different decisions on this. I mentioned just one there, which is Davis and Nottingham Forest, where the High Court held that there was no express incorporation of Rule K arbitration rules in the manager's contract, Davis being the former manager of Nottingham Forest. That was the contention, but the court held, however, that there was still a binding arbitration agreement, and therefore both parties were bound by the FA's rules. The court went on to state that anyone who participates in the game of football, certainly at the professional level, is fully aware of the importance and the standing of the rules. Moving on to the Court of Arbitration for Sport, just keeping an eye on the time, so I'll whiz through it fairly briefly. CAS was established in 1984 as an independent institution to arbitrate and mediate in relation to sport. There are about 300 arbitrators from 87 countries. They have to be independent, can't have any connection to the case or the parties. Normally about 300 cases a year are registered with CAS. It can be used by individuals or legal entities, so that includes athletes, clubs, sports federations, organisers, sports events, sponsors, and even television companies. The proceedings are normally conducted in French or English, but other languages can be used in certain circumstances. It does have power to order interim measures or suspend the execution of a decision whilst it's making its final substantive decision. Its awards and decisions have the same enforceability as court judgments. In terms of procedure and how to use CAS, there are two ways. There's the ordinary arbitration procedure. This is used for contract or tort disputes, normally in front of a three-person panel. The proceedings are confidential, and in principle, the awards and the actual decision itself are not published. Messi and Barcelona, which I've spoken about previously, could have been referred to CAS to obtain a resolution using this procedure. Had Messi decided to go to Manchester City, CAS's interim powers could have allowed that to take place. For example, the transfer could have taken place and then any issues that arose later on will be dealt with by CAS, but interim measures could have allowed it if they'd gone down this route. The other way in which CAS can be used is by way of the appeals arbitration procedure. And this is used for disputes resulting from decisions taken by international bodies of sports organizations. Under these procedures, an appeal can only be lodged once you've exhausted all of the internal remedies of the relevant sporting body. Again, normally these take place in front of a panel of 3. The arbitrators rule on the basis of the regulations of the governing body concerned. They look at the matter de novo, which means that the parties are free to raise facts and arguments not raised in prior proceedings, which is an important point which I'll come to briefly when I speak about Manchester City. The appeals arbitration procedure doesn't specify a need for confidentiality, and therefore, unless the parties agree otherwise, the award can be published. So, Manchester City in the news over the summer because of its appearance before CAS. So between 2012 and 2016, the club received payments from various companies linked to its owners. These payments were said by UEFA to be cash injections disguised as sponsorship payments to circumvent the financial fair play rules, which require clubs to financially break even. UEFA found City to be in breach of the FFP rules and fined the club €30 million and banned Manchester City from the Champions League for 2 years. City appealed to CAS. CAS reduced the fine from 30 million to 10 million euros, which is significant, but maintains the penalty because it disapproved and stated that it disapproved of City's failure to cooperate with UEFA's disciplinary investigation. City's position, for what it's worth, is that it chose not to cooperate with UEFA because the UEFA proceedings were biased. More importantly, CAS held that City could not be banned from the Champions League as the alleged breaches of the regulations were not established and were time barred. There is limited scope to appeal from CAS. If you do, then you need to go to the Swiss Federal Supreme Court, where you can appeal on limited grounds, such as the lack of jurisdiction, violation of procedural rules, e.g. the right to a fair hearing, or incompatibility with public policy. The Casta Semenya case is a good example of an appeal from a CAS decision. This was published last month, and the Swiss Federal Court, the Swiss Supreme Court, rejected her appeal against the award by CAS, where CAS had upheld the legality of the so-called testosterone rules imposed by the World Athletics Association, which she had challenged by way of ordinary proceedings. The Federal Court, Supreme Court, confirmed that its jurisdiction, including assessing whether the CAS decision had violated widely recognized principles of public order, and it further stressed that any violation of public order could only be said to take place if it was manifestly untenable, clearly disregarded important principles, and shockingly offended the feeling of justice and equity. So as you can see, it's a very, very high threshold in order to have success in front of the Swiss Supreme Court. And finally, just in terms of CAS, there is also scope to pursue mediation rather than arbitration. This is non-binding and informal. Parties can attempt to negotiate with the other party with the assistance of a CAS mediator to resolve the dispute. Either the parties agree the procedure to be used, and if they can't agree, then the mediator will impose a procedure. The mediator will propose, but will not impose solutions. So I hope that's helpful. Just a whistle-stop tour through some of the organs in which sports disputes can be resolved. Thank you.
Great, thank you very much for that, Mark. I'd just like to follow up with a couple of questions, if I could, before we
Sure.
hand over to any questions from the audience. You mentioned towards the end of the talk the Man City UEFA FFP case, and that seems to bring to light one of the drawbacks you get with the sports arbitration dispute resolution forums is that they don't have the same powers of compulsion that a court has, for example, to force parties to disclose documents or to call witnesses. City in that case obviously repeatedly refused to disclose to UEFA certain documents or to call witnesses. They did when it got to CAS, and CAS reached a decision on that basis. But even though I think CAS had the powers to force them to do that. And something we often do at Mishcons is we use a call to action to obtain evidence first, and then that evidence can then roll over into cases used in the arbitration forms. For example, we might get a search order. We did that for a Premier League Cup a few years ago. Is that a tactic that you see often done in order to get the evidence that otherwise isn't going to be produced for these forums?
Yes, it's one of the things which needs to be considered on its merits, as with all things, but I've done it personally in the Defoe case that I mentioned on behalf of Sky Andrew. So I represented Sky Andrew. A key issue that arose was whether Jermaine Defoe had undertaken a negotiation with Portsmouth himself, or whether Mitchell Thomas, the unlicensed agent, had been involved. Mitchell Thomas, being an unlicensed agent, wasn't under the FA's jurisdiction, and therefore he refused to disclose his phone records. Jermaine Defoe disclosed some phone records, but our understanding was that there was a different phone that he'd used on the day. So we had to go to the High Court and get an order against Vodafone to disclose Mitchell Thomas's phone records. Those records showed that on the day in question, there were approximately 45 phone calls between Jermaine Defoe and Mitchell Thomas on transfer day, which was held by the tribunal to be quite likely to indicate that Mitchell Thomas had been involved and advising Jermaine Defoe in breach of the contract with Sky Andrew. So it's something which can be done. There is a difficulty in that it can slow down proceedings. So where time is of the essence, it's often the case that you just sometimes need to press on and take a view.
Sure, okay. And on the point of actually timing, one of the issues in sports disputes is obviously that the timing of a final decision or resolution is so crucial because sport's moving so quickly. And there's a sense that clubs can get bans, for example, on signing players or competing in tournaments postponed by appealing to CAS or whatever it might be. I know people thought that City would do that as a way to postpone a Champions League ban. That didn't happen as it happened. But it often does seem to happen. And on the flip side, for example, we had a case involving Birmingham a couple of years ago, and they were hit with a 9-point deduction. And that although the charge was brought 7 months earlier, the decision was issued in March, towards the end of the season, obviously. And 9 points in March didn't actually condemn to relegation, but it's pretty hard to make up those points at that time. Is it something that's quite open to abuse for clubs or anyone else charged to manipulate the timetable in these forums so that it suits them?
The proceedings, disciplinary proceedings in particular, can be quite protracted anyway. So to some extent, clubs just kind of push an open door by making applications for evidence, etc. Sorry, someone's done a post about Ronaldo versus Messi, which I found a bit distracting. Yeah, so the proceedings normally can take quite a bit of time. So what clubs will do is they'll make applications for evidence and disclosure and witnesses, etc., which stretch things out even more. So as you mentioned, Manchester City were in a position where the timetable meant that had there been anything going adverse or looking to be adverse against them, they would have tried to get the matter kicked into the long grass for a further year to allow them to play in the Champions League. Sheffield Wednesday, which I mentioned in my talk, there was an 8-month delay between them being charged and the points deduction being imposed. As a result, it was imposed during the summer after the season finished, which meant that they avoided relegation, and it meant that Charlton were relegated. So if that matter had been dealt with swiftly, then obviously Sheffield Wednesday would have had the points deduction much earlier, and they would have been relegated and Charlton would have stayed up. So the stakes can be very, very high.
Absolutely, indeed. Okay, one final question before we move on. Of the various panels you mentioned, the ones you've appeared before, do you have a favourite one?
Rule K.
Rule K?
Yeah.
Any reason?
Very flexible, wide range of disputes. As I mentioned, everything from issues regarding the name of a club to players, agents, phone calls. There's a wide range in ambit, and anything that involves a dispute between a participant, so the club, agents, players, can be dealt with under the Rule K jurisdiction. There is scope for interim remedies to be used, which means that matters can be expedited. A very user-friendly way of resolving sports disputes. It is becoming increasingly lawyer-centric, lawyer-focused, and I think there's limited scope for a lay person or a small amateur club to appear successfully in front of a Rule K panel. But overall, I'm a firm favourite of its flexibility.
Excellent. Okay, Rule K then. Tom, I'll bring you back into.
Thanks very much, guys.
Questions from the audience?
Yeah, we've got about we've got about 5 minutes to run for a few questions from the audience. So we're going to try and pick the ones that are specific to sports disputes as opposed to more general ones. However, at the end, I'm going to try and run through as many as we can by giving a short answer as possible. So Mark, perhaps one for you. What's the best forum for resolving legal issues regarding governance in sporting member associations or clubs? So is it to go to the local courts or to CAS? And do parties actually have a choice over these matters, or are their hands already tied?
It depends very much on the governing statutes under which they operate. So there'll be some situations where they're compelled to go to a particular organ, whether it's in a national forum, or they may alternatively be required to go to CAS. So it's very situation specific, to be honest. There isn't a general rule.
Fantastic. We've also had a question which isn't necessarily sports disputes focused, but it's one that's particularly interesting. And I'll leave this one open, and if no one answers, I'm happy to address it. What are the legal issues and the main reasons behind the rejected Saudi bid for the acquisition of Newcastle? Any of the panelists want to take that one on?
Tom, you've done a video on this, haven't you? So
yeah, I think I definitely planned one. So yeah, this one of the main sort of areas of law that this pulled in was the owners and directors test, which is a set of rules that the Premier League have, which prospective owners have to fulfill in order to become owners or directors of a Premier League club. And this is what's seen to be the key issue. Unfortunately, a lot of this is confidential, and there have been very few details that have been released. But there was at least allegations that the acquiring party had links to the Saudi state, and the Premier League were looking into this matter in determining whether or not this fulfilled the owners and directors test. And there's so many different political issues came into play here. But one of the allegations at the moment is that the Premier League took too long to come to their decision as to whether or not whether or not the owners and directors test could be passed, and which is what led to the proposed investor pulling its investment because the investment agreement had a time limit on. So yeah, that was the sort of the very short version of that. Mark, perhaps a question for you. Doesn't the Mewtwo case also hamper the free movement of players? Because paying 15.2 million is ridiculous, but clubs won't be willing to hire a player ruining his career. Not sure, quite follow that one. I'm not sure if you've got any better interpretation than me.
I don't follow it, and everything that's happened in the past 16 years since Mewtwo was sacked suggests that the free movement of players has not been an issue.
Fantastic.
Chelsea did pay about that amount for him, I think, didn't they?
I think it was based on the salary that a bizarre calculation or manner of assessing the damages based on the salary that he would have earned during the remainder of his contract. He then had to pay it to them.
So Mark, we've also got a question on how FIFA prohibits recourse to the ordinary courts. So you mentioned the journalist Gutierrez case against Newcastle. Yes. In relation to his cancer treatment. So how was Gutierrez able to appear before the national courts or the employment tribunals rather than going through CAS?
Well, he would only go to CAS. I mean, as I mentioned, there's two ways of going to CAS. You can either follow the ordinary procedure or through the appeals procedure. So he chose to go through the employment tribunal. I can only assume, to be honest, it's not something I've given much thought to, but I can only assume that if he'd been unsuccessful in front of the employment tribunal, he will then have tried to bring a claim using the FA's various tribunals. Although he may then have had some conflict issues and then have had to go to CAS subsequently after that.
Fantastic. So from a harder question to a much easier one, what's been everyone's favourite case they've been involved in and why? Pete, do you want to start with that one?
Ooh, I think probably not from a legal perspective, but I particularly enjoyed one I did a few years ago for Phil the Power Taylor, the retired but still leading darts champion of all time. I think he ended up with 16 titles in the end, and he had a big bust up when he moved sponsors from to Target from his previous sponsor over the trademarking of his name. His former sponsor trademarked the Power without his knowledge, which was all fine when the parties were working together, but becomes an issue when Unicorn, his sponsor, left him and would carry on using the Power, and he was like, well, that's my name now, you can't use that. And you see that a lot in IP disputes, but that was a great fun case to work on, to deal with Phil Taylor, to find, as a darts fan, to find out a bit more about the inner workings of darts, and to ultimately to get him the trademark back so that he could be the Power and no one else was the Power.
And Mark, in 30 seconds.
In a non-sporting context, I've represented a porn star, but I'm not going to go there. But in terms of sport, probably the Defoe case, very interesting, high profile, involved Daniel Levy, Harry Redknapp, Peter Storey, Defoe, Daniel Lloyd, the WAG. So for a whole variety of reasons, that was very interesting.
Fantastic. And while I was mentioning that, I think that feels like the right time to draw an end to today's session. So if you do have any further questions, please don't hesitate to reach out to speakers. As we said, this is one of 8 modules, so we'll be covering lots of different topics. I've seen lots of questions about Brexit and how that will impact on sport. We've got a whole session just on immigration where we'll be discussing Brexit just before the end of the transition period. I do want to say a massive thank you to Simon, to Mark and to Pete for their time today, and also to all of you for joining in. So as I said at the start, our next module will be released on the 30th of November. Now, this is an essential module for anyone looking to develop their understanding of sponsorship, image rights and tax. And we've got 3 different lectures, one from my colleague Anne Rose, who's recently advised Castor on their £25 million sponsorship deal with Rangers. Unfortunately, you've also got to listen to me again talking about image rights, why they're important and why clubs and players enter into image rights agreements. And for the final part of the session, we've got some tax specialists. I promise it won't be boring. They're very, very good speakers, and they advise over 70 of the Premier League's footballers on all aspects of their tax affairs. For those of you who might be interested with a legal career with Mishcon de Reya, please don't hesitate to get in touch with our graduate recruitment team, who you can find on our website. We actually have a deadline for this Friday to apply for a virtual open day, which is one of the new things we're trying. So if you are interested in that, please contact graduate recruitment. And we're also exploring different ways and how we can provide work experience opportunities for those of you who are on the course. So thanks very much again for joining. The recording will be available shortly afterwards, and we look forward to seeing you again on the 30th of November. Thanks very much for your time.